defense counsel don't ever ask about other defendants, and the bankrupt defendants being, not going to employ future defense counsel, they're not there to defend themselves. You'd think they take more pot shots at them than they do, but if you're there on behalf of one joint compound defendant, you'll ask your questions, but you're not going to ask about the other joint compounds. Now, maybe you should, find Jesus and start asking about the bankrupt ones, but you're never going to ask about the people who aren't there to the deposition who've already settled. The reason you're not going to do that, well, one, because everyone has these handshake deals not to call names at each other among defendants. There's also the issue that in many instances the defense lawyer asking the questions about product A, his firm's also counsel to product B and product C.
There's the rub.
And he's not going to get in there and start asking about, well, what about the other joint compounds you use? I see that company B and company C aren't here today. Did you settle with them? How much did you settle for? Can I see your settlement releases? Can I see the claim forms you use with them? You don't hear this. You don't hear any of that with regard to the CMO stuff. It's kind of why I say in jest and in all seriousness, the bankrupt defendants have little asterisks and footnotes and little party hats on because everyone thinks they're there for the benefit of their defendants. But it's completely inconsistent with how they wish to treat these bankrupt defendants compared to each other in the tort system. And I have no problem with treating the bankrupt defendants just like any other empty chair. But that's not what's being asked for.
Isn't that what's being asked for? Because if you could ask the plaintiff, what trusts are you going to file claims with? Or if you could do an interrogatory to say what trusts you're going to file claims with, why can't the court simply, as part of the CMO, just order it? I mean, unless there's some reason that information isn't discoverable. And I think that's really the question. It's not what you can do in discovery. I think the defendants think it's discoverable information because defendants are concerned that the memories will change after the case is finished. And that's what the concern is.